Mr. Witherby.
Thank you, Your Honor. May it please the Court. My name is Reed Witherby. I represent Jim and Kathleen Kelley and their law firm, Kelley Law Associates, P.C., who appeal from a Superior Court judgment that they breached a contract with the plaintiff, Alfred Saggese, to pay him a referral fee of some $88,000. The first point is that on the facts that the Superior Court judge found, there was no contract. Mr. Saggese and the Kelleys entered into a 3-year lease in December 1996. There was no discussion of referrals for a fee at that time. The client, Victoria Gunther, came to Saggese's office in January 1997, and he introduced her to Kathleen Kelley. The court found there was no discussion between Saggese and Kelley or between either of them and Gunther about Saggese receiving a referral fee. Kathleen Kelley then sent the client, Gunther, a fee agreement with a copy to Saggese. And that fee agreement made no mention of any referral fee. The court concluded, I am not convinced that in those early weeks, Saggese was explicit about his expectation of a referral fee on the Gunther case. Those facts established that the engagement and the referral were a done deal. Later, Mr. Saggese indicated to the Kelleys that he expected to receive a referral fee on the work that the Kelleys did for Ms. Gunther. And the court found that the Kelleys gave apparent acquiescence in that expectation.
Mr. Witherby, is there any reason as a matter of law why, even if there was no, forget about the rules, professional rules for the moment, just as a matter of pure contract law, that in the course of the dealing with a third party, the parties can't agree to, the contracting parties can't agree to a contract from this point going forward? In other words, if I say to you, I didn't say at the beginning that you should pay me a third, but I'm now asking that you pay me a third. The consideration for this is that I will bring you additional clients.
Well, if there had been a testimony and evidence that the court accepted to the effect that there was something else that constituted consideration, then that would have been lawful.
Well, then, but I'm looking at, who's it, Judge Fabricant's?
Judge
Sanders, finding that the fee that Saggese insisted on for all of them, including the Gunther matter, this is at page 39 of I think, the record appendix, was that the Kelleys pay him 1/3 of any attorney's fee they generated. I take it that could be 1/3 of the attorney's fees that they generated from the time that he had insisted that was going to be the case. Now, whether the insisted meant you can't rent from me, I'm not going to refer you any clients, I don't know what the consideration was, but why wouldn't, assuming that there was consideration, why couldn't there be a contract at that point?
I think in theory there could be a contract if that had been the deal. But the deal I submit that the court found was that the Gunther case was the first case that Mr. Saggese referred to the Kelleys. There was no discussion of him getting a fee. They entered into an engagement letter, an engagement agreement with Gunther on an hourly rate basis, and then only later did he come and say he expected a fee for that referral.
Right, and my point is that they could have said, no, we'll give you referral fees we'll give you a 1/3. Again, I'm looking at her findings. In those early days, he wasn't explicit, so no contract. Just because he wasn't explicit, failure of meeting of the minds. But by the end of February and into March 1997, a month later, he had referred other clients and made it clear, I take it, as to each, which she found he expected, right? And then she says, I find that Saggese made it equally clear at that time that his expectations for the referral fee extended to the Gunther matter. So at least beginning in March, don't forget this is hourly rate, so it's not a 1/3 or something like that, and who knows what the fees are going to be. So going forward, I want 1/3. Was there a meeting of the minds? Well, she says, she doesn't use the meeting of the minds language, but they began to pay him.
Paid him $2,512, which included some money on the Gunther case. So they agreed
It
to
looks
this.
as if they agreed.
So therefore, contract.
Well, Your Honor, respectfully, I don't think the judge found that they agreed to a global agreement. I think the testimony was that there
They
was an agreement
acquiesced
on
in the arrangement, is what she found.
Right.
I mean, I don't know whether that constitutes a contract, but they acquiesced in the arrangement.
And then Mr. Saggese went into the office from time to time and reviewed pending cases, including Gunther's, so kind of keeping an eye on what was going on and inferentially on the fact that he would be getting a referral fee. So all this seems quite supportive of her findings that a contract existed. And then you're arguing her findings, or you're not arguing any one of them is clearly erroneous. You're just saying as a matter of law, there can't be a contract.
No, what I'm arguing is that this deal was a done deal before there was any discussion of other referral
I
fees,
understand that, Mr.
and that there was no testimony to the effect that Mr. Saggese said he would give them other cases if they would pay a fee on Gunther as well as a fee on the other cases.
Did you raise an affirmative defense failure of consideration?
No, Your Honor, but
I mean, it seems to me that if anything, I mean, that's how you usually get to a contract that's, an arrangement that starts and then there's a claim of a later contract. I'll accept the judge's findings that there was no contract ab initio.
Your argument really looks to me like it's being raised for the first time on appeal.
I think that's not true. From the Kelley's point of view, they came into this case denying that there was a contract, and their pleadings denied that there was a contract. This put the burden on the plaintiff to prove that there was a contract and to prove all the elements of the contract, one of which is consideration. This was not a failure of consideration, a situation where there was consideration, but then something happened, such as the death of a party who was going to perform a service, that undercut the existence of consideration that had previously existed. This is a simple failure to prove that there was consideration in the first place. And the situation that the judge found was that they had entered into the contract with the client, and that was a done deal. And then Mr. Saggese came to them and tried to impose upon that arrangement an extra term. And although the court found that they apparently acquiesced in that, there's no finding that this was part of a global agreement. It was a case-by-case referral understanding.
Well, we can certainly ask Mr. Cohan about consideration. Am I correct in understanding that the rent was being paid? The rent was being paid,
Yes, Your Honor.
and they were splitting expenses?
I'm not exactly sure of the details. I know they were sharing office space, and they had a lease arrangement under which they were sharing office space.
Why doesn't this agreement violate the Rule 1.5 sub E, in which case neither of you people should recover anything? I mean, aren't you supposed to get the client's agreement in advance as to all of this?
I submit that it does violate
Sure,
rule.
people, if we uphold the judge's finding that in February or March They agreed to pay Mr. Saggese a one-third referral fee. Shouldn't they have gone to Ms. Gunther at that point and say, what do you think about this?
Well, Your Honor,
I mean, they're just as blameworthy, perhaps, as he is.
Well, I would submit they aren't as blameworthy. Let me just, if I may, deal with it logically. Under the judge's findings, Mr. Saggese apparently knew that he wanted to charge a referral fee. Mm-hmm. But he did not raise this with Ms. Gunther when he met with her individually or then, in the presence of Kathleen Kelley to convey the referral. Nor did he speak up when she sent an engagement letter to the client that made no mention of such an agreement. Mr. Doniger, the plaintiff's own expert witness, testified that it's the custom and practice in Massachusetts for the referring attorney to undertake the responsibility to make disclosure and obtain consent. He testified with respect to the receiving attorney that it was good practice, which I clearly agree with, to check that had been done. And the Kelleys did not do that in this case. But it's clear as a matter of the expert testimony in the case that it's primarily, and it makes sense because Mr. Saggese is the one who knew he wanted to charge a fee. Under the judge's findings, the Kelleys did not know that until after the fact. They had reached their agreement with the client. And yes, it would have been better if they had followed up rather than making the assumption that Mr. Saggese had done what he was supposed to do.
What is your position? Let's assume we find there is a contract, as the judge did, oral contract, and it's enforceable. Let's find there is a contract. And then we determine that the rule violates it, that it violated the rule. What should we do with this judgment in his favor?
The judgment should be reversed, and Mr. Saggese should take nothing. And your people should be able to keep all the money? That's correct, Your Honor. This is money that they earned. This is money they earned, through very hard work. They're talking about the judge found that it consumed the time of their office for over 2 years. Most of the time of their office, they went into. They advanced $150,000 of attorney's fees and $33,000 of expenses.
But they wouldn't have earned any of the money if it hadn't been for the plaintiff.
That is correct, Your Honor. They would not have. I submit they would have been in a much better position if this case had never been referred to them. They would have not had to go through.
Well, maybe not. They were struggling young lawyers. Maybe they wouldn't have gotten another client. I mean, we never know.
What do we make of the letter from the client to Ms. Kelley?
Approving the agreement?
I think there are a number of problems with that letter, but the basic problem is that the rule is intended to provoke action at the start of the engagement.
But it doesn't say that.
But it clearly is intended. I mean, it doesn't use those terms, but it clearly contemplates that. The original rule talks about disclosing, the employment of the other lawyer. So, and it clearly contemplates obtaining the client's consent in advance of doing all the work. And it also taught the new rule, Rule 1.5, which came into effect during the pendency of this case, talks about joint participation. And the whole point is that the client is supposed to have some knowledge and input into the financial and arrangements and the arrangements for the responsibility for the case. And that purpose of the rule is not served if you wait until the case is over and then you disclose and seek consent. At that point, it doesn't even make sense for the client to have any input into potentially altering an agreement, not in this case, but potentially altering an agreement that lawyers had. They could have entered into a fee-splitting agreement in 1990, and in 1998, when it's all done, the client could say, I don't consent. And that would upset their expectations.
I'm surprised they didn't settle this case, because once this opinion comes out, the Board of Bar Overseers may have a profound interest in looking into the conduct of everybody involved in this. maybe.
Your Honor, I see my time is also up, pretty much up. If I could just say, I also think that the statute of frauds argument is well worth this Court's consideration. Mr. Saggese, by his own testimony in the Court's findings, was acting as a finder, and he did not provide any professional services. And I submit the contract is unenforceable. For that reason, I would rest on my brief for the other arguments.
Thank you, Mr. Witherby. Mr. Cohen?
Good morning, Your Honor. Let me start off by saying that I think you got it right. There is an enforceable agreement here.
Well, where's the consideration?
The consideration was that, as you said, he's going to continue to submit clients to them, and he could at any time.
Where's the case law that says that that can constitute consideration for an existing arrangement?
Well, there's more, Judge. He could at any time gone back to Gunther and said, look, I made a mistake sending you to them. I'm going to send you to someone else.
Oh, and then that would have been a very nice inquiry for the Board of Overseers.
Well, you know,
Tortious interference. I mean, there's no suggestion in the record anywhere that at the time that the referral was made for this client that there would be any referral fee, correct? And a referral fee is just that, a referral fee.
Well, Your Honor, with all due respect, that's not entirely true, although the judge found that to be the case. In fact, there is testimony in the record from Mr. Saggese that he spoke with Ms. Gunther at the very first meeting and said to her, don't worry about my fee, I'm going to get paid from their referral fee, and she acquiesced. Her testimony was she didn't remember that happening.
So you're saying the judge's finding with respect to that is clearly erroneous?
It's clearly erroneous. I haven't directly addressed that in my brief because I don't think it was necessary. They're bringing up an argument now for the first time on appeal that they didn't bring up in the trial court, so we're a little bit hobbled here trying to...
What's the issue that they brought up for the first time?
Past consideration. They have come into court and into this court.
Well, because I think Mr. Witherby's answer to that was we said there was no contract. If there's no contract, I don't have to prove that there was a failure of consideration. You say there's a contract, and I'm saying, where's the consideration?
The consideration was the actual referral of Gunther to them. Now, you say that happened first, but they acted like that was the consideration. What the judge found was a contract implied in fact, because they acted like there was a contract.
But she found that at the beginning there was no contract, and it's a referral fee. He never sought to say you cannot continue to recommend her, to represent her. That would be dubious conduct at best. No question that going forward, at least according to her facts, he made it clear that he wasn't going to refer, that any referral he made, he expected 1/3 of the fees.
But doesn't the law also say that when someone receives a benefit, past consideration supports a contract? Isn't that what the Gleason case says that I cited on page 35 of my brief?
It can in certain circumstances.
Well, isn't this one of those circumstances?
No, it could be. It could be with respect to the future cases that he's bringing.
And it could be with regard to this particular case, that he's got an ongoing relationship with them. Remember, they're side by side in offices. They're not partners, but they're offices. And he said, look, I'm expecting a 1/3 on everything I give you, just as you said before, including the Gunther case. And they never said no. Now, doesn't that also create an estoppel? He's continuing to send them business. He's continuing to send them other clients.
Possibly, but I'm just focusing on the original contract. It's a referral fee. The referral had been done. No, he's never claimed, I want 1/3 of whatever work you do in lieu of rent or telephone or secretary. He's saying, I'm going to refer business to you. I won't refer any business to you unless you pay me 1/3 of what I do refer to you. He's already referred Gunther.
And so you're
And
saying...
if he wanted to receive 1/3 for whatever they billed, which, as you know, is a fairly extraordinary arrangement in any event, if he wanted to receive 1/3 of whatever he billed before he referred her, he should have made that clear. Once the referral is made, the consideration is for the referral.
Well, actually, I would suggest that the consideration is for more than just the act of the referral. It's for the continuing involvement and the continuing assurances to the client that this is the right guy for the job.
But the client knows nothing about this. The client doesn't even know that there's any financial involvement. I mean, that may be what the purpose of the rule is, but that's not what the judge found. I don't know why they paid the one-third, amounting to the $2,000. I don't know why they did that. It could be all kinds of reasons. But there were, at least as I can see it, if there was no contract at the time of the referral, there was no referral fee.
I would suggest that there was a contract at the time of the referral. I would suggest to you that Mr. Saggese would not have sent Gunther over to Ms. Kelley's office in the first place had he not believed.
I mean, he might have believed that, but a belief in your mind doesn't a contract make. And the judge...
Well, if it's later clarified and the parties agree to it, then of course they can continue on that new understanding, can't they? I mean, if there's some uncertainty about exactly what the terms of a referral are, and then it's clarified and the parties assent to the clarification.
Thank you, Judge Cordy. That's exactly what happened. There was that clarification afterwards. He goes and says, I want a third, and makes clear that he's expecting.
Isn't it important that they, in fact, then went ahead and paid him some fees pertaining to Gunther?
Yes, they did, Your Honor. And they confirmed in a letter to the client that we have an obligation to pay the fee, but we can't pay it without your consent. So you've got it all kinds of ways from their side that there was a meeting of the minds on this contract arrangement. And I agree with you, Judge Marshall. There was some gray areas in the beginning, but it was certainly clarified, and they operated under the assumption
But
that
the larger problem, at least to me, is that this whole arrangement violates the rule. So what should we do with this judgment? They're all at fault, in my opinion.
Judge, I agree with half of what you're saying. There's no violation of the rule, but if there is a violation of the rule, then they're both at fault. There's no violation of the rule because the rule has no time frame on it whatsoever. And we can talk about what is logically implied in that ethical rule, not a rule of law, an ethical rule.
What is the purpose of the rule? Is the purpose of the rule is it to protect the client and no more?
Well, I think that that's precisely what the purpose of the rule is.
Well, let me ask you this. Let me sort of put the shoe on the other foot here. If the client, all these payments had been made and dispersed, the client then says, this was an unfair contract. It was unreasonable, and then sues both lawyers, both sets of lawyers. Can the client, and the client recovers the judgment, can the client look to Mr. Saggese to pay all of the amounts that were unfairly paid, that were excessive?
You mean if the client sues the Kelleys and says, you charge me excessive fees?
Yeah.
Can he also sue Saggese on that? I would say no. He didn't have a contract. The client has no contract with Mr. Saggese. His contract is with the Kelleys.
But the rule is designed to protect the client from unreasonable fees, isn't it, in a fee-sharing situation?
I think what they're saying is, yes, that's part of the purpose of the rule, to make sure that the total fee is reasonable.
Yeah. So to the extent that it's excessive, can the client then recover that excessive amount paid from Mr. Saggese?
No, Your Honor, I would say no, because they don't have a contractual arrangement with Mr. Saggese.
There's no attorney-client relationship between them?
I guess that's going to depend on the situation. In this particular situation, I believe there was a continuing attorney-client relationship because Mr. Saggese helped her out in other ways and stayed on top of the case for her and was involved at different points in different aspects of this case.
This is an unusual case because, in a sense, because, as I understand the terms of the contract, viewed one way, they could be anything that the Kelleys build. I want one-third, Saggese. They could be anything that you collect, one-third. Not very clear, is it?
Oh, I think it's absolutely clear that it's one-third of the fees that are collected, and that doesn't mean recovery of expenses. And that is not unusual. That's standard throughout And as much as our expert said, well, it's unusual to pay it a third on hourly rates, he did say that it does happen from time to time.
Was there testimony by Mr. Saggese that he suggested to the Kelleys that they increase the hourly rate to cover the referral fee?
I believe the testimony was, consider, when you set your hourly rate, consider the fact that you're going to have to pay me a third.
But doesn't that go to the heart of what the problem is here? The thing about contingency fee arrangements is that there's often not a close correlation between the award, which is typically damages, and the amount of time expended by the attorney. Sometimes that accrues to the attorney's benefit. Many times that accrues to the attorney's loss. The attorneys may put in hundreds and hundreds of hours, and the ultimate damage award might be far less significant than what they had hoped for. What troubles me deeply in this case, and Justice Glaney's question troubles me even more, is that whatever the reasonable hourly rate was, and $175 is not unreasonable, that Saggese is saying, well, just bump it up so that I get my one-third. I'm not doing any work. So you're adding on a one-third for no work performed.
Your Honor, what you're talking about is how, it goes to the question of how attorneys set their fees and why they charge a certain hourly rate and why they're willing to give up part of that fee so they'll get business. These young kids, baby lawyers, if you will, got themselves one huge fee, and they worked hard for it, and God bless them for it. But they wouldn't have earned a penny of that if Saggese, with all his years of experience and training, hadn't steered this business to him. He's a rainmaker. People out there go out of their way to get next to guys like this because you can get business from him. And otherwise, you're sitting there in your office hoping that somebody will call you.
I'm looking at it from the protection of the client's point of view. Clients may be coming to him thinking that he will be the attorney, right?
No, Your Honor. Clients come to him because they respect his judgment and opinion, and they know that he will steer them to the right guy.
But
Shouldn't they know beforehand that he is steering them to a particular lawyer because that a lawyer has, in effect, agreed to pay him?
Well, in some respects, I agree.
I mean, isn't that what the rule is designed to do, so that somebody can say, now, are you only referring me to this because this attorney is paying me $33? I mean, I'm looking at what the purpose of the rule is here.
The old rule did that. The new rule doesn't do it. The new rule, with all due respect, is not terribly well drafted. It just says you got to let them know before you split it.
I'll stipulate to that.
Excuse me?
I'll stipulate to
Costs a lot of
that.
trouble.
And I don't think that you can
Shouldn't the client-
penalize my client for obeying the rule as it's drafted.
But shouldn't the client know all the arrangements in advance? I mean, suppose I'm the client and the referral is made, and I say, my usual fee is $200 an hour, but the referring attorney says I should take into consideration in charging you my hourly rate the referral fee, so I'm raising it to $300 an hour. What on earth client is going to agree to that?
That's a hypothetical that I
Well, the
doubt.
hypothetical's on page 6 of your brief. Wasn't there some testimony, a trial that by Mr. Saggese that they should take into account in setting the hourly rate, his referral fee?
Well, taking it into account doesn't necessarily mean they're going to raise their rate. It just means that they've got to make that determination. And when they decide whether they're going to take the case, they have to decide whether or not they're willing to do it and give up a third of their fee. It doesn't necessarily mean they're going to raise their fee.
I have to say, part of what we have to do here is resolve this case, but we also have to provide some guidance to the bar. And one of the pieces that sort of seems to me almost meaningless is her post hoc agreement that the fee be paid, because she had agreed to pay X amount of dollars, 200 and something. She'd already agreed to that, right? So for her now to agree that of that, one-third goes to one lawyer and two-thirds, it seems to me to be really just superfluous.
Well, we have no client. We have a client that's approved the payment. We have no client objecting here that the fees were high or that the services were not appropriate. The client is fully informed. Isn't that correct?
That's right, Your Honor, and that is exactly what the rule requires. But look, you raised 2 points. One is, what do you do with this case, and what do you do for the future?
Right.
And for this case, the client wasn't harmed. The client agreed, and everybody acknowledges that this was the deal, so he should get paid.
Leave it the way it is.
Leave it the way it is.
and write
However, for the
something.
future, if you wanted to say, this rule means you got to tell them in the beginning, I would applaud you for that. But the rule doesn't say that. So don't penalize my client for complying with this rule as it exists. And if you're going to penalize and the law is also clear that where two people have violated an ethical rule, that doesn't vitiate the contract. We've got that in Massachusetts. We've got it throughout other states. So they shouldn't get the whole trough just because where they violated the rule themselves.
Well, I certainly don't see any intentional violation of any rule here.
Thank you, Your Honor. There isn't.
Thank you,
Thank
Mr.
you.
Cohen.
Done? I guess we're done.
All rise. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting at Boston, within and for the Commonwealth, at present depart and give your attendance at this place tomorrow morning at 9 o'clock, to which time and place the sitting of this court is now adjourned.